Madam Deputy Speaker, we've been here for, is it 14 hours? And just about 14 hours today. I'd just like to remind the House, I'm just hoping that some of us might slip out. I'd just like to remind the House, Madam Deputy Speaker, of the bill that I rose about 6 hours ago to...
Members, we have been here for 14 hours. This is very unnecessary. Please do not disrespect the chamber. Please do not disrespect me. Please let the Attorney General finish his closing statement.
I thank you so much. Madam Deputy Speaker, the bill that I rose to pilot this, well,
Madam Deputy Speaker, the member for Diego Martin Northeast is using obscene, insulting language in the chamber.
Yes.
For a very seasoned politician.
Okay. Member for Diego Martin North. There is a manual.
I can tell you what I said. I said, don't point up the Deputy Speaker like that is your daughter. Go home and do that. Go home and do that. Go home and do that. Don't do that here.
There is a manual on the House of Representatives. If you turn to the middle page in that manual, there is a table with words that are not allowed in this House. That word is not in the table. I ask you to refer to that manual, member. I would ask you to withdraw what you said and apologize.
I apologize and withdraw.
Honorable Attorney General.
Madam Deputy Speaker, for the third time, when I rose to pilot the bill before the House about 7 hours ago, I had read the long title of the bill. Just for the benefit of my colleagues, the long title is that this is an act to provide for special measures. Now, I just want to repeat that, just in case some of us did not hear. An act. It's an act. Okay? This is not the Constitution. It's an act to provide for special measures for upholding and preserving the rule of law, public order, citizen security, and public safety within certain geographically defined areas of Trinidad and Tobago and for other related matters. That's the long title of the act that is before us. Now, right away, beginning with my distinguished colleague, Senior Counsel, Mr. Scotland, the representative for Port of Spain South, and continuing thereafter, because Mr. Scotland stands above most of his colleagues in terms of his position on the bench. But Mr. Scotland carried me straight to a case. And the case was the case from Jamaica. On purpose, I did not go to that case. You know why? Because that case is a case on a constitutional provision. And that provision is analogous to Section 8 of the Trinidad and Tobago Constitution. That is an exercise that we are in right now, and which was before the court, not the Court of Appeal, the court in Jamaica, a full court, 3 judges, not the Court of Appeal. Now, Section 8 of the Trinidad Constitution, it's not an act per se. It's the Constitution. As all the constitutions in the region do, Section 8 is a provision which deals with states of emergency. What does it say? It says, subject to this section, for the purposes of this chapter, the President, as she did in Trinidad a few months ago, may from time to time make a proclamation declaring that a state of public emergency exists. That's 8.1. 8.2. A proclamation made by the President under subsection 1 shall not be effective unless it contains so and so, and etc. Now, we are here this afternoon, this morning, because the state of emergency declared by Her Excellency the President in July of 2025 is coming to an end. This government will not go back to a position where the criminals run the country. We have decided to pass an act. This is not a constitution. It's a piece of legislation. But my friend and all of his cronies on the front bench or the back bench referred me to the case of the Attorney General of Jamaica versus Douglas. Now, cases are important things. If I could just, I know it's late, but if I could just have a minute or two of your time to carry us through just a few sentences in the case to illustrate a point. At paragraph 2, that's just after paragraph 1. The judgment which is given by Mr. Justice McDonald Bishop says this: the government's utilization of states of public emergency. What's he talking about? He's talking about a state of public emergency. How do we know that? Because he says so. He's talking about a state of public emergency. There was nothing in anything that I said when I piloted the bill that said that I was talking to you about a state of emergency this afternoon. As a matter of fact, I'd forgotten state of emergency behind me. I have a piece of legislation in front of me. And I don't know, there's something called, I know that I have some colleagues who are doctors on this side of the bench. I see one at the very end of the bench. There's something called, I'm told by my medical friends, folie à deux. And then there's something called folie au village. Well, I'm told, I'm not a doctor, that folie à deux is the kind of madness that takes place when two mad people speak to each other and They have a conversation. They alone know what they are talking about. But they carry on a conversation, and then they do all sorts of things. And folie à voyage is when a group, not two, of people. So you now have, yes, something like that, a caucus. A group of people sit and they convince themselves that they are talking about something that the rest of us, well, we sit and say, well, we don't know what's going on here. We don't get involved. And I have sat here this evening for 6 hours. I'm a patient man, but I've sat here for 6 hours this evening and I've heard states of emergency, I've heard discriminatory states of emergency, I've heard about disproportionate states of emergency, I've heard all sorts of things about states of emergency. And my friend from Port of Spain, North St. Anne's West, actually carried me to a paragraph in the case. He said it was 62. Well, as a good student, I'm looking at 62. But I think it may have been 70. Paragraph 70.
You didn't know where it was?
No, I think so. I'm subject to correction. So if he's correct and I'm wrong, then I'm prepared to say 62. We won't fight over that. So I think it begins at 70, but it could be 69. I heard 62. Now, what it said is this. And he went on to discuss, because I think he took me to, so he went on to discuss, he said it was my friend from Port of Spain, North St. Anne's West. He said he was talking about detention orders. But I saw detention orders written about in paragraph 74. Sorry. And at that point in time, again, I just read the first 2 lines because I know it's late. The judge says, it seems pertinent to note as a starting point that in evaluating the detention of an individual within the legal framework of a state of emergency, one cannot, so
Misrepresented the only policemanship.
So he says, so if I could just, it's late and it's bedtime for some people. So he says, in evaluating the detention of an individual within the legal framework of a state of emergency, one cannot divorce the legality of that detention from the constitutionality of it. But what I have to say, colleagues, is that wherever we were this for the last couple hours, let's try on this side of the bench of the House at any rate to purge our minds of that and to go back to the bill, the long title of which I read for you at the very beginning. So there are a couple differences between a state of emergency and the zones which forms the subject of the legislation that is before us this afternoon. The first one, and I hate to start at what I describe to be building blocks, those alphabet blocks that you see, A, B, C, and so on. But really, a state of emergency is constitutional. I think I said that already. The zones that I came here to talk about this afternoon, well, those are statutory. And that's why there's a piece of legislation before us. It's legislation, an act. That's what I started with. Now, there are a couple other things. The states of emergency, because they're in the Constitution provides for national level states of emergency. The zones that I thought I brought here this afternoon, well, they only focus on specific communities and specifically defined areas. Now, in the case that my colleague referred to, AG versus Douglas, what the court, first of all, the decision had absolutely nothing to do with zones. So let's just get that out of the way. So when they brought the case up, let's just describe that as part of that thing that I spoke about, the Foley thing. Folie à viage or folie à deux or trois or quatre or whatever it is. So when they looked at the AG versus Douglas, that case held, and it held this and this alone, that the repeated use of what? States of emergency as a normal crime-fighting tool is unconstitutional. That's what the decision of the court was. Now, the Court of Appeal, well, it's not it's a full court, 3 judges, but different court system. They're not in the Court of Appeal, but they have not ruled that the use of zones is unconstitutional. Okay? So, and I dislike coming to the Parliament of Trinidad and Tobago and in essence carrying on a class that I have carried on for, I mean, the rest, all of my life, I've been trying to run away from the University of the West Indies teaching law. And I mean, I had a teacher, the teacher sitting next to me. And I think my teacher knows that I was pelting away from the Faculty of Law. But here I am this afternoon, tonight, this morning, trying to teach the difference between a piece of legislation, the Constitution, a decision on the Constitution, and the fact that there is no decision on a statute. So, colleagues, I just want you all to understand that for us to begin, right? Now, just one more point, if you all will indulge me. The comment was made that the Constitution, the bill, whatever it is, they describe it as, that its provisions breach the separation of powers. And that is because my colleague said, well, it's the executive declaring the state of emergency. Well, I think the lawyers on this side, the Prime Minister just sent me a note to remind me. I am sure the member for Sama Barataria, the member for St. Joseph, the member for Tabakit, and others, just some of us might know that the executive is in our system comprised of, yes, the president, but all of us who sit. Okay, I didn't want to put it like that. You know, I'm just trying to get us out of here at a decent time. But the member for St. Augustine is saying something which I think is correct, okay? So that the Prime Minister is part of the executive when she sits at the head of the cabinet. As is the President. The President is the head of the executive. The Prime Minister, I don't think, has decided a case in the High Court. I don't think that she sits above the High Court or Court of Appeal judges. She's not, let's just try to do it by process of elimination. She's not the head of the judiciary. I think we have a head of the judiciary. I think I read that somewhere in the newspaper that there is a new Chief Justice. I might have seen that somewhere. And that's called the judiciary. The legislature is another arm. And then there's the executive. So to say that, you know, well, the state of emergency that the president is okay to issue, to sign off on, that for some reason or the other, a piece of legislation which says the Prime Minister is not okay to sit and say, well, okay, there's a problem in this community because of a separation of powers, is a nonsense argument. Now, so we are back to the constitutionality of the bill. And I say the bill, not the Constitution. So we're not dealing with the constitutionality of the Constitution, which is a nonsense in itself. The constitutionality of the bill. I've given the arguments. The law now is Surat and Suraj proportionality. We did not need to stick a special majority certificate on this piece of legislation. Minister Hussain is saying yes. And that is true. Because the Privy Council now says to us, and Mr. Arawi was one of the architects of that. Every second word out his mouth was Suraj, and every third word out his mouth was Suraj. Only two cases. There are two separate cases. Two separate cases. Okay. But in those cases, Baroness Hale said, listen, govern yourself. Just do it in proportional terms. But you know what? We stuck a special majority certificate on this piece of legislation because we want them to agree with us and to pass the legislation. We want this to be their only crime-fighting tool in the last 10 years. Because really and truly, all that they have done this evening, tonight, this morning, is to tell us why this will not work. And you know what? They went as far as to say that they drafted a bill this time, eh? So let's forget the folia, whatever. They drafted a bill in 2017. They drafted a bill in 2017 to deal with localized states of emergency. And one of my colleagues on the other side said, well, you all shouldn't take any great pleasure from that, you know. We did it first. I have news for him. That's been kicking around for about 20 years. Because I happen to have been Attorney General before, and I saw in the National Security Council precisely that sort of legislation. And you're looking now at 2005, 2006. Okay? So that's a bill to declare parts of Trinidad and Tobago areas where you need special attention. After riots, sometime under their tenure, they set up a study group led by Mr. Watkins, I think the member for Port of Spain South might be familiar with that.
Don't take anything
And
he says.
there was a recognition that certain parts of Trinidad needed certain specialized attention. Now, I'm not saying that for a second, that specialized attention extended to the type of attention that we think it requires. But I make no apologies for piloting this piece of legislation. It is hogwash to say that there is anything that is racist about this. I would never. The member for Toko Sandy Grande said he would never be a part of anything that discriminates. And the Prime Minister, who is sitting on my left, I know the Prime Minister for over 30 years, would never be a part of any legislation in this country that discriminates against any group of people. All that we are determined to do, and we said it on the campaign trail, all that we are determined to do is to return to Trinidad and Tobago law and order. And that is not old talk and reasons why this constitution thing might not work, and reasons why this might be difficult, and reasons why this. No, if they are difficult, we do the difficult things precisely because they are difficult and hard, but because they need to be done. It's not going to be easy to fix this country. It's not going to be easy to turn this country around from a decade of cozying up to the criminal elements in every institution of the state, in the URP, in the CPEP, and in their own private dealings. Where every Monday morning they were hopping on a train, on an airplane, going God alone knows where, to do whatever to break sanctions. Madam Deputy Speaker, the bill before the House is the government's attempt to establish zones, and those zones will be the zones in which we will concentrate to eradicate the scourge of violent crime in this community. With those few words, I beg to move.
Honorable members, the question is that a bill entitled "An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago and for other related matters" be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled, "An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago and for other related matters."
Honorable Attorney General.
Madam Deputy Speaker, in accordance with Standing Order 681, I beg to move that the law reform zones of special operations, special security and community development measures bill 2026 be committed to the Committee of the Whole to be considered clause by clause.
Honorable members, the question is that the law reform zones of special operations, special security and community development measures bill 2025 be committed to the Committee of the Whole to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clauses 1 to 28.
The question is that clauses 1 to 28 stand a part of the bill. The question is that clauses 1 to 28 now stand a part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 1 to 28 now stand a part of the bill.
The schedule.
The question is that the schedule stand a part of the bill. The question is that the schedule now stand a part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The schedule now stands part of the bill.
The preamble.
The question is that the preamble be approved. The question is that the preamble to the bill be approved. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honorable members, the question is that the bill now be reported to the House. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The bill will now be reported to the House. Honorable Attorney General.
Just Madam Deputy Speaker, I wish to report that the law reform zones of special operations, special security and community development measures, Bill 2026, was considered in the Committee of the Whole and approved without amendment. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the law reform, zones of special operations, special security and community development measures bill 2026. Those in favor say aye. Aye. Any against say no. No. I think the ayes have it. Honorable Attorney General.
No division. Okay. Madam Deputy Speaker, I beg to move that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago and for other related matters be now read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Provide for Special Measures for Upholding and Preserving the Rule of Law, Public Order, Citizen Security, and Public Safety within certain geographically defined areas of Trinidad and Tobago and for other related matters be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. This bill requires 3/5 majority.
Mr. Padara?
Yes.
Mrs. Bisasa Essie?
Yes.
Mr. Tanku?
Yes.
Ms. John?
Yes.
Dr. Munilal?
Yes.
Mr. Lee?
Yes.
Mr. Hussain?
Aye.
Ms. Amin?
Yes.
Mr. Alexander?
Yes.
Mr. Maraj?
Yes.
Ms. Mohit?
Yes.
Mr. Sturge?
Yes.
Dr. Bodo?
Yes.
Dr. Dowlat?
Yes.
Mr. Morris?
Yes.
Ms. Benjamin?
Yes.
Mr. Sobers?
Yes.
Mr. Watts?
Yes.
Dr. Sicharan?
Yes.
Mr. Kiza?
Yes.
Mr. Elder?
Yes.
Mrs. Sam?
Yes.
Mr. Narayan Singh?
Yes.
Dr. Rupnarayan?
Yes.
Dr. Gozain?
Yes.
Mr. Thomas?
Yes.
Mr. Sampson?
Yes.
Mr. Gonzalez?
No.
Mrs. Beckles?
No.
Mr. Imbed?
No way.
Dr. Gatsby Dalim?
No.
Mr. Young, SC?
No.
Mr. Dino Breaker?
No.
Mr. Scotland?
No.
Mr. Manning?
No.
Mr. Marcel?
No.
Mr. Devines?
No.
Mr. Ramin?
No.
Madam Deputy Speaker, the result of the division is as follows. 27 members voted in favor for, 11 members voted against. There were no abstentions.
Honorable members, with a division of 27 members voting for, 11 members voting against, and 0 abstentions, the motion for the third reading of the law reform, Zones of Special Operations, Special Security and Community Development Measures, Bill 2026 is approved.